member can. Thank you, JD.
Oh, excellent. Thanks.
All right, so once again, I'm just recapping for those of you that we're starting the recording now. The first thing that you need to do is you need to draft the language of the recall petition, and you need to appoint a committee of people that will be responsible for the recall. The sample language of the recall petition I've already drafted and forwarded to people. Don't worry too much about the reason for the recall. That can be very generic because they can't reject the petition because they disagree with the language. But typically it would be something to the effect of this individual has a conflict of interest with homeowners. This individual has not been representing the owners and taxpayers of this metro district properly. This person is not discharging their duties properly, something to that effect. But just use the sample language on that petition and move forward with that. Okay. After you've drafted the petition, don't circulate it. Please do not circulate it, because if you do, you'll get in trouble. It'll be rejected. Instead, what you have to do is you have to file it with the court in the district file. Every metro district has a file when they organize it. It is created in the district court of the city or county. Usually, I mean, if it's either going to be the county, or it's going to be city and county of Denver or city and county of Broomfield, if it's the city and county. So you have to file with the court in those counties. Typically, you do that with what's called a motion to intervene, because ordinarily, under the electronic filing laws in Colorado, ordinary people just can't jump into a lawsuit without requesting leave to intervene. I've drafted, and you should have, if you don't have it, I will provide it to you, a copy of a sample motion to intervene. What the motion to intervene needs to do is it needs to basically say that you're moving to intervene for the purpose of initiating a recall petition. You cite the statute regarding recall petitions, which is Colorado Revised Statutes 32-1-906 et seq, which means the sections that follow it in sequence. Those sections require that you have to file the recall petition in the county and or the city and county, if it's a city and county, where the district is organized, in that district file. You also have to request the court to appoint a designated election official. Now, the designated election official, really it should be, I would recommend just use the same designated election official that conducts your regular district elections. I mean, I know that a lot of people don't like that because it's usually the person that's appointed by the developer, but realistically, I don't see the problem with that. We routinely use designated election officials, which are paralegals or attorneys of some of these law firms, and they know the rules, and they're not going to play games if you do things the right way. So go ahead and use whoever is your designated election official. The reason why I suggest that, for two reasons. Number one, they are already designated by the district as your DEO. Aurora Highlands, there's I forget her name, but she's one. You should have that on your certificate canceling the election, for example. It indicates, I believe it's a person that used to be Collins, Cockrell and Cole, and then Paul Cockrell left and formed his own firm, so it's Collins, Cole, and something else now. Their law firm. But I have that person's name. You can look at it on the certificate. That's who the district appointed as the DEO. So they can't argue with you. They can't fight you if you pick the same person that they picked as being unqualified. Why would you want to delay this anymore? Don't give them reason to delay. Just pick their DEO and move forward with that. Does that make sense?
Yeah.
Okay.
Hey Brian, quick question. That DEO does not have to be in the district, city, or county.
No.
Is that correct?
That's correct. The DEO has to be a Colorado registered elector, but typically they're just they're just a paralegal at one of the law firms. They don't have to be in the same county. Okay. So,
great, thanks.
So whoever your district's DEO is, and usually there's an administrative resolution adopted in January the first meeting of the year that says who the DEO is. There's just an election that was either held or canceled. Whoever signed the order, either canceling the election or the order calling the election, that DEO used that person. Okay. All right. So the first thing the DEO has to do is the court issues an order appointing the DEO, which usually happens real quick, like within 5 or 10 days. The DEO then has to determine in a short period of time whether or not your petition is satisfactory or not. And the DEO will either say, yes, your petition is satisfactory, or the DEO will say, no, there's a problem with it. And if there's a problem with it, you have to file a new petition with the DEO again. My recommendation is if you use the format that I provided and you scrupulously follow it, you should be in real good shape. To just use that same template, and the DEO will probably approve it without a problem. Okay.
Just a footnote there, Brian, real quick. On the 2 that I did, we were in a fairly hostile situation. The DEO did play games with us, but they have a deadline in which they have to approve the format, and they also have to tell you what's wrong with it.
That's correct. That's correct.
So you fix what they tell you. I can't tell you how many times they told me to put a comma here and put a semicolon there, and it was just a lot of BS. But we got through it. It took about a week, and eventually we were done. So yeah, you just play their game, but eventually you'll get there.
Right. Well, look at the forms that I sent you. They're pretty thorough. They're pretty detailed. They have all the magic language in it. The one thing that's real important is you're not allowed to separate, the forms. You can't separate the first page from the final signature page. You have to have all the information, warning people on each page so they know. Just follow the form. Use the same Word document, and you should be okay. All right.
And that's an important point. We stapled them so that you had one package for each person you were recalling, and we had, I think, spaces for like 15 signatures or 20 signatures. So each subsequent package with another 20 spaces for another 20 signatures has to be stapled. It's real important because if they see the staple's been removed or it looks like it's been altered in any way, out the door goes all those signatures. So you really have to be very religious in respecting that packet and basically treating it like a very treasured item, because if it's disturbed in any way, they'll just kick it out.
And now I want to point out one thing. You can have, as John says, you can have multiple people circulate the petition, but only whoever circulates a single petition, a single packet, has to sign that one. So you can't pass it back and forth to different circulators. Okay, the same person that circulates the petition to 20, 30, 40 people has to be the person that signs it at the end. You can't have someone else sign it if they weren't the one circulating. Okay, you can have, if you have 4 or 5 people circulating it, you can make 4 or 5 people. You can make packets for 4 or 5 people for each person. So if you're trying to recall 3 people, for example, each person would circulate 3 packets, one for Director A, one for Director B, one for Director C. If you've got another person circulating, they'd also have 3 packets, one for Director A, one for Director B, one for Director C. Does that make sense? Yeah, because you can't mix them up. You can't have different circulators circulating the same packet of signatures. Okay.
Yeah, and when you see the form, Brian has some. I threw in one I had. You'll see what we're talking about. It's really helpful just to spend a half hour looking at the form and figuring it out. And I also had some coaching comments that we used in training our people, and I threw that in my email as well. So.
Right. Okay. You have okay. Once you've circulated the petition, keep in mind the only people that can sign it they must be registered electors of the district, all right? So you need to make sure that if you're circulating the petition, that it's only going to be residents of the Metro District whose address on file with the Secretary of State matches an address within the district. And in addition, you need to be very careful that if they own property in the district, that they are registered with the clerk and recorder's office or the assessor's office, whichever, as being the owner of the property. It can't be in the name of an LLC. It can't be in the name of a trust or something like that. All right, does that make sense? Otherwise, they'll kick it out. And actually, you know, if you kick too many out, you wind up losing. So make sure their registration with the Secretary of State for voting is accurate. Make sure their address is an address in the district. If not, I mean, it takes 2 minutes. You can sign up as you're in their doorway, you know, circulating the petition or whatever. You can say, hey, are you registered at this address, the Secretary of State? And say, oh no, I need to change my address. You can change it right then and there. It takes 2 minutes to sign on to the, My Vote Colorado or whatever it's called. It's a website where you can easily check your registration and change it. It takes 2 minutes to do that, and then they'll be okay. Okay, after you've collected enough signatures, now the question is, how many is enough signatures? It's the lesser of either 300 valid voters in the district or 40% of the total number of registered electors, whichever is less. So in the case of small districts, it may be 40%. In the case of larger districts, it may be 300. I guess I'm not that familiar with how many registered electors there might be, and it's constantly changing, like in these new neighborhoods like Aurora, Highlands. I mean, I don't know if we're talking about 100 people that have moved in or 1,000 that have moved in already. But, you know, just try to figure out about how many people are registered. And it's not just homes, it's registered electors. So you should assume that there may be more than one registered elector per home.
And you can get that number. You can actually get the lists from the county registrar of voters.
Right.
That you'll know exactly what you're working with.
Yeah, you can ask them for that, and they'll provide that to you if you want. Okay, once you've done that, you then submit the petitions when you think you've got enough signatures, and I would make sure you have at least 20 to 25% more signatures than you need, because there's always going to be a few that sign it that, for whatever reason, are not registered to vote or doesn't get kicked back. What you do is you submit it back to the designated election official, and the designated election official, as John said, has a very short period of time to determine whether or not they're adequate. And they do a rigorous comparison of every single signature with the voting records to see if, in fact, they can match them. If they can't match them, they'll tell you, well, we've got some we can't match, and so either they'll say it's sufficient if they can match the 300 or the 40%, in which case you're done, or they will object to some of that and give you the chance to cure. There's a question here. 6-month grace period for board members. What if new members are unqualified or conflict of interest? Well, then you don't recall them. If they're unqualified, at any time, they are no longer an eligible director, and they should be kicked off. So you probably should investigate, but you don't recall them. Instead, what you just say is you just challenge them. You can file a petition with the court if they can't prove it. So I would go to the attorney, go to the DEO, whoever qualified them, and say, provide me some proof that you're qualified. And if not, I think you can raise that issue. Now, the conflict of interest, that's different. A conflict of interest by itself does not disqualify a person, okay? They can still serve on the board despite a conflict of interest. They're not supposed to vote on certain things except as allowed under the conflict of interest statute. So under certain circumstances, they can vote if they disclose a conflict of interest and their vote is necessary to make a quorum. So conflict of interest, the 6-month rule it's not going to make a difference. They're not going to get disqualified. If they're not qualified, You don't recall them. You just basically say they're no longer on the board. And if you necessarily need to ask the court to make a decision, you ask the court to make a decision.
So can I expand on the question then, Brian?
Yeah.
So if they're already a sitting board member that is not qualified, regardless of the conflict of interest, if they're not qualified and they've been there for a year, 20 years, whatever the period of time, is there a need to go through a recall procedure for those seating?
No, there's no petition for that.
Aha. Okay.
And similarly, it's just like if someone moves out of the district and they no longer own property in the district, the day they A, no longer live in the district, and B, no longer own property in the district, when both of those are true, they're off the board automatically. And if they never had property in the district, as soon as you challenge them, they're technically off the board unless they can prove otherwise.
Interesting. So that's two avenues. There's the recall avenue, and then there's the qualifications avenue. Yeah. And the recall would entail things like conflict of interest or maybe whatever else, right?
Yeah. Yeah, go ahead. Dr. Charles.
Yeah, I was just going to say
they're not fulfilling their fiduciary duties. Like, what if they've never attended a board meeting or
that's a good reason to
something like that? Can you get rid of them? How would you get rid of them?
Well, okay.
And less than 6 months, just never came to a meeting.
Okay, number one, you can recall them. Number two, the problem is they've probably been excused each time. The statute says that if you miss 3 board meetings, you're automatically off unless you're excused. And so I guess the question is, was their excusal legitimate? And if so, maybe the people that excused them should be recalled for improperly excusing this person. But that's a good reason to recall them.
Yeah. And again, just keep in mind on the reasons. You can put anything in there, and under the statute, when somebody signs that, they don't have to agree with that reason. They could have their own reason to recall it. It's just something that's kind of orients folks, but it really doesn't have any, controlling significance. People can sign that for any reason or no reason. They can just sign it. And what you put in there, it's not something you have to prove. It's not something you have to present evidence on. It's just something to, trigger the process.
Be a little careful, though. Excuse me, John. One thing I want to just chime in on. Be a little careful, though. You don't put in anything in the reason for recall that is factually false, because there is some case law that if it's blatantly factually false, like this person was convicted of murder in 1989 when they weren't, that it could be grounds to say that this is fraudulent. So be careful of that. But go ahead, John.
Yeah. Don't make any misrepresentations, but opinions are opinions about their performance, that sort of thing. And then in terms of the question about their qualification or not qualification, it's a judgment call, but if you think the litigation or the argument about whether they're qualified or not qualified, it's going to take some time or prolong, you lose nothing by including them in the recall. You can still recall them, and that will be definitive. If they're recalled, it doesn't matter whether they're qualified or not, they're out of there.
So with that in mind, John, you could do a pincer movement, right? You could do both simultaneous efforts, a recall and hey, we challenge the qualifications of this individual.
Yes.
There's no reason not to. It just means, you have one more packet in your hand when you knock on the door.
Does it have to be an existing board member that calls that into question, or can, like you were saying before, Brian, anybody can file a motion to intervene based on this person being unqualified?
It doesn't have to be a board member, but the nice thing about being a board member is you have an attorney-client privilege with the attorney for the district, and therefore they have to disclose to you the information that they have on whether or not this person is qualified. So presumably, this person submitted some information to them that they were qualified to be on the board. And I think they have the duty to investigate that and to present all the information to you as a board member.
So
This is gold.
regarding the question that was asked a little earlier about what if you've got people on the board that have been there for a year or 20 years or whatever, and they have been qualified under the, I have an option to purchase thing. What do you do with that?
Ask them to prove that they, ask them to provide the option to purchase, ask them to prove they paid taxes.
Yeah. You could do a background check too, and if any of them have felonies, boom. You know.
Well, so anyway, so those are, I mean, those are, like I say, two separate things to do. So let's go back to the recall again. Once you've circulated the petitions, at that point, you go back to the DEO and you submit the petitions to the DEO. The DEO has a very short period of time to determine whether they are adequate or not. The DEO will get the record, get the voting records, will get the property records, and will attempt to determine whether these people are qualified or not. The DEO may say there's some people they can't determine one way or the other, and then the burden would be on you as the raising the petition to prove that they are qualified electors. But if the DEO sees that there's plenty of signatures, more than the 40% or 300, whichever is less, they will certify it as being qualified, as being a petition that is appropriate in the proper form. The next thing, this is very interesting. Once the DEO says this is a good petition, okay, the petition is then presented to the board to set an election. Now, at that point, when they present the petition to the board to set an election, the person or persons being recalled have the opportunity to resign. If they resign, there is no election, there's no recall election, and then the board has the opportunity to fill that vacancy. Now, that could get a little tricky because the board can only fill the vacancy from qualified electors, which ordinarily would be citizens who either are registered to vote and have property in the district or residents of the district, okay? They cannot qualify new people through that option to purchase contract if there are people in the district that are willing to fill the vacancy. So if you've got residents willing to fill the vacancy, they can't play those games again of trying to qualify someone through, you know, an employee or a consultant or a contractor of theirs or a friend of theirs that doesn't live in the district or have property in the district. And that's pretty powerful to know, okay? So as long as there are enough qualified people in the district that want to serve on the board, then they can't qualify these other people and they can't play these games. Now, could they pick someone that's already qualified? I mean, my understanding is like Carla Ferreira in Aurora, Highlands. Well, she's already on the board, but you know, she's already has a contract to purchase. I don't know if she has some friends that live with her or a significant other or something like that that might be willing to be a qualified elector and replace one of the board members like Michael Sheldon. But that's something that they could do. They could find someone friendly to replace them. Okay. But they can't qualify new people through that loophole. Well, then that's pretty straightforward. If they don't qualify someone, and if they don't appoint someone, if the person doesn't resign, then there's a recall election. The recall election is set by the board, just like they set the May election. You know, they send out a notice of the election. They have to publish it in newspapers, etc. They also have to solicit names for people that would fill the position. So you have to have your people lined up as to who is going to replace these people. And my recommendation would be make sure it's pretty well known as to who's going to replace each of the people that's being recalled. So if you're going to recall 2 people, make sure you've got 2 people lined up that are going to replace them, and they'll submit their petitions. Once again, it's the same self-nomination petition that people like Nick did when they applied to be on the board. It's a very simple petition. Basically, just just fill out that form. Okay. Any questions on that? Okay. They have to set an election within typically 120 days, but if there is an election already scheduled for within 180 days, they can hold it at the same time as that regularly scheduled election. I don't think there's any elections. I don't think in any of your districts there's an election scheduled for November. If there is, like because of a bond issue or something like that, they potentially could schedule at the same time. But otherwise it'll be held, typically within 4 months, which depends on when you get the petition submitted. But we're talking sometime in the fall, probably.
Hey, Brian, follow-up question that I posted: if you're filing, if you're challenging board members, then what's their role, if any, in that process when you referred to, hey, the board decides and picks an election date, et cetera, et cetera? The folks that are being challenged, are they included or excluded from that activity?
There's nothing in the statute that prevents them from picking an election date. But once again, picking the election date is pretty ministerial because, once again, the statute provides it has to be within this narrow window. And they'll pick a date. Always pick a date 120 days plus or minus, whatever falls on like a Tuesday or something like that. And you can't really do it sooner than 120 days. You got to do the nomination solicitation. You've got to do the mail-in ballots. You've got to.
Sure.
It takes about 120 days. So, I mean, yeah, arguably they may be under a conflict of interest, but the 120-day period is pretty much fixed by statutes. There's not much they can do to play games there.
All right. Thanks.
And then otherwise there's an election, and at the time of the election, it'll be just like the election that was held in May for those districts that had an election. It'll be a mail ballot election where they send the mail ballots out about 3 weeks before, 3-4 weeks before. They typically have a week after the ballots are due to be counted and abstracted, and at that point they'll announce the official results. And they'll announce there's going to be 2 questions on the ballot for each candidate that's being recalled. One, shall the candidate be recalled? And then number 2, who should be the replacement? So that's why there has to be a replacement that you pick. And once again, when I say you, it's the committee. The committee should pick an appropriate person that is going to fill each of these vacancies in the event that the recall is successful. And I hope the recall, you've lined up all your ducks in a row so the recall is successful.
Can I ask you to elaborate on those replacements? That committee there, I mean, I got the impression that a committee would have, you'd have your replacements lined up in advance, of course.
Oh.
But who does the placement of those individuals?
Well,
the committee doesn't have any authority, do they?
No, they don't. But those individuals have to submit the self-nomination petitions to the DEO.
Okay, so as long as they raise their hand and there's blank seats, they're going to fill up until there's no more seats, and then you'd have to have an election.
Well, be careful, because the way it works with the recall is every single person that's being recalled, if they're recalled, then there's a person who's going to fill their seat. So, like I say, the committee needs to sort of coordinate with the candidates that are going to replace them. So
right.
you don't have 3 people. Let's say you've got 3 seats. There are 3 people you're recalling. You don't want all 3 of them to fill the same seat and then have 2 vacancies that the board can pick someone else for. You want to make sure that it's decided in advance that, okay, person A is going to
specific seats.
This person's seat, when this person's recalled, person B is going to fill the 2nd seat, person C is going to fill the 3rd seat. You don't want them running against each other.
Right. Likewise, you don't want 10 people saying, hey, I'll serve. And you're like, wait, there's only 3 seats.
Right. I mean, you may have other people that sign up, If you do have other people that sign up, then you're going to have to tell the voters, and hopefully the voters will be those people that signed your recall petitions. Hey, we want you to vote for this person. We don't want you to vote for this person that just happens to be a construction contractor employed by the developers, friends or something.
Indeed.
Yeah.
Great clarification. Thanks.
And that's about it, really. I think I've given you all the forms that you need. If you don't have those, let me know and I'll make sure, or John, I think you've got those. I think you sent them out already. If anyone doesn't have those forms or needs those forms, let me know. It's a fairly straightforward process. It's just that, like I say, it's very technical. You've got to dot all your I's, you got to cross all your T's. You got to make sure you don't have any recall petitions submitted before they're approved by the DEO. If you do, they're invalid.
Good question about the ballots. Are they going out only to those residents that live in that metro district, or is it a wider audience?
The ballots go out to all the registered electors of the metro district. So that would include anyone that is registered to vote in Colorado and their address to Secretary of State is within that district, or people who own property in the district and are registered to vote.
Got it.
Brian, I was just forwarding to JD a couple of the attachments. Thought since we had a little bit of time, we could pull those up and just do some show and tell so they can see what they look like.
Hey, John, if I can ask before you guys jump to that topic, Carice has a question on the financing of the recall.
Yeah.
District pays.
The district pays the cost of the election. That's correct. Obviously, if there's a campaign committee that's going to be established, you got to comply with the campaign laws. So to the extent that you're going to raise you're going to spend more than $200, or if you're going to raise anything, you got to create a campaign committee, which you can do on Tracer, the Colorado Secretary of State's office. I mean, I had a contested election. I'm one of these people that I'm afraid that I'm going to lose an election, so I always create a campaign committee. I always advertise. I always spend money. I registered with Tracer, and I created a campaign committee with Tracer, and I won my election with 90% of the vote. But you still have to be careful to make sure that that you win. Otherwise you're wasting your time and your money.
And that's just relevant if some individual is going to spend money. But I think to Carice's question, if you initiate a recall, everybody that's involved in let's say the committee, as long as nobody's, taking out ads, you're basically just volunteering your time. And then when you cross the T's and dot the I's and get this filed, the district in its infamously amazing budget can start paying the bill, right?
Exactly. The district pays the bill for the designated election official. District pays the bills for the mailings. District pays the bills for the counting of the votes.
Oh, really? That's good.
Yeah,
It's a really good point too, that I think you guys want to be prepared for, is that the board members who are the developers in this case are going to use that against you by saying that you're costing the community money. So be prepared for a response to that when that happens, because that happened to us in Solterra. It does cost the district money, but you're doing it for the benefit of the community because you're trying to change the direction of this board.
Well, especially if they've adopted, hundreds of millions of dollars of debt for the district. $30,000 versus $100 million of debt is a drop in the bucket.
I think JD's got a couple of those documents. If you could pull up the petition.
Right. See the law, the language at the top in bold, that's real important that you copy that verbatim. That's what I call magic language in the statute. You just got to fill in. This is for two district that I helped do the recall for, but you put in your own district in that case. But make sure that you use that. Make sure it's in bold. Make sure it's in the same font, the same type, everything like that. If it's too small, they don't allow it. The petition to recall, you put the name of the director in there. pretty straightforward. Petition text. See, this is the kind of language you want to use. David Lemna, operates under a conflict of interest as director due to his private interests as a managing member of this company. He's placed the interests above the interests of the residents and taxpayers. He's caused to be public, if true, false legal notices saying that a budget is available. In that case, they actually submitted a budget, and then when the residents called to ask to get a copy of the budget, they said there's no budget available. But you don't have to put all that in, but the first couple sentences is good enough, You also have to list the names of the committee members. In this case, there were 3 committee members and their addresses. That has to be on the petition, just like that. And then you have to have, once again, this is more magic language. I am an eligible elector in the political subdivision mentioned in this petition as shown on the registration books of the county clerk and recorder. I have not signed any other recall petition to recall the aforementioned person. I hereby demand an election as a successor to the elected office in this recall petition. And then they have to make sure you have to have the signature, the printed name below it, and it should be legible so they can, because they're going to try to compare it. If it's an illegible signature, they're going to kick it out. The residence address, city and town, the county, and the date of signing. It's important that every single one of those blanks be filled correctly. And then you do that for every single person there. And I just have additional pages attached. And on each page, I always include that same warning is against the law language. Just clear. Okay.
And the affidavit at the end.
Let's go to the very end, the affidavit. That's real important.
Yep.
There you go. Affidavit of circulator. Page breaks were sort of weird. This really should start on a new page, the affidavit. But basically, the person that circulates it has to fill in the blanks as to their name and the address. And it's real important that every single one of these statements is true, that they were 18 years of age or older, they circulated the petition, they made no misrepresentation. And that's why, for example, I wanted to point out that make sure in that statement, the reasons for the recall, you don't include anything that is blatantly a false statement of fact, because that they will say the recall petition is invalid because there's a false statement of fact or a misrepresentation in there. Signatures have to be affixed in the presence of that person. To the best of this person's knowledge, they have to be a resident and an eligible elector of the district. And once again, you have to make sure that you can't pay the person for that. Can't pay the person for their signature. That's bribery. And then it has to be notarized if you go to the very bottom. And make sure that this last page cannot be signed and cannot be notarized until the last signature of the person that you want to count has signed it. Because otherwise, if you see a date that is like a day after the date of notarizing, they're going to say, wait a minute, this is false because this was notarized before the last signature was collected.
Yeah. And then for what it's worth, that the very last document, JD, is that circulators instructions that I had. Well, that's the petition to the court.
Yeah, that's basically the motion to intervene or the petition of the court, basically to ask the court to appoint a designated election official and approve the petition.
Here, let me send it to you separately, JD. It doesn't seem to be in what.
There's a +5 there, so there's more documents.
Oh yeah, thank you. There we go. So it'd be the last document.
Boy, is there ever. All right, here we go.
Yeah, so this was just kind of a coaching sheet that we used in training our folks. And it kind of covers a lot of the things that Brian has just talked about. I made the point in the first paragraph that you've got to think of that petition as an appendage of your body. We had some folks say, well, I knock on the door and the wife said, oh, let me take it into my husband. He's out in the back. And you have to politely say, no, I have to witness that signature. I have to see the person actually sign it. So however we can arrange that, but because when you sign that affidavit at the very end, that's what you're saying is you were present, you witnessed the person sign it, and you're swearing to that fact. We talked about the separate sections, registration. We invited the people signing it to read the warning at the top of the petition. That's in the bold language. They had to sign in black or blue ink, no purple or pink. Obviously can't sign twice. Yeah, we had people, they would sign beneath 5 or 6 people who would also sign, and they'd use ditto marks, ditto for the county, ditto for the address perhaps. And we had to have them say, no, you can't use ditto marks, you have to spell it out. We were pretty particular too. We had them spell out Jefferson County, not Jeffco, Lakewood, that sort of thing. We just didn't want to give the DEO, who was employed by the developer, any reason at all to invalidate the signature. And invariably, there's going to be mistakes, and there's a discipline process for how you correct mistakes. And at the end of the day, the safest thing to do is just draw a line through it and have them sign in the next space available all over again. Circulators, you can have people from outside the district circulate it, but they have to identify themselves as such. Obviously, in most cases, you're going to have neighbors, your committee circulating, and we had them with wear a badge saying volunteer circulator.
That's required by statute, is it, John? That's something new to me.
I don't think it is in the statute. I don't remember where that came from. I don't know if it was in the earlier statute. I don't remember where that came from, honestly.
It can't hurt, I don't think it's strictly required.
Yeah, Brian, we went down because we knew that they were going to find any potential thing against us. We went down pretty strictly with this. I'm not sure, to your point, if it's necessary for all, but we think it's a good idea to do because chances are they're going to try to do something as well to invalidate. Yeah,
but this, and that's all I really pay attention to. And I guess, kind of the backdrop to it is when you have we had 26, we had a committee of 20, well, we had a committee, I guess, of 3 or 4, but we had 26 people circulating our petition. We got, I forget what it was, 784 signatures. It's like with anything else, you've got to get them together, go over exactly how this works, the instructions, work with them. We were, JD and I worked on this together. I would say I was on the phone with circulators at least a couple times a day throughout the process, answering questions, coaching, helping, making arrangements for extraneous situations. So point of it is you need some organization, you need somebody, 1 or 2 people kind of spearheading the effort, and like anything else, encouraging, coaching, and getting folks out. My wife was the smart one. I got 250 signatures knocking on doors. She put a note on the social media site and said, come on by the house. And we had a line outside the door for a couple nights. People came to us to sign. So anyway and every way, you just got to be there and witness the signatures. Thanks, JD. Other questions?
Well, it's time for questions now.
Were these successful when you guys do them? What's your success rate?
Oh yeah, we were successful. In our case, the entire board resigned within minutes before the designated election official certified the petitions as sufficient. They were waiting until the last minute and trying to figure out what to do. And the entire board resigned from all of the districts, including the developer district. We think we think they screwed that up. We think they were in such a snit and it was last minute, and literally they were a day and a couple of hours late. But put that aside, we're bearing down on them pretty hard, and they resigned from all of them, including the developer district, which was a real coup.
Wow.
So, right. Yeah, it was very, very successful.
Yeah, in the two districts I'm familiar with recalls, in Two Bridges, same thing. The developers, once the number of petition signatures was accepted by the DEO, they resigned. In one case, Four-Way Ranch Metropolitan District, they didn't resign, but instead the recall went ahead and they were recalled at the next election.
Good, very good.
Well, if they, if everybody resigned from the developer district, was there anybody qualified to serve on that board?
Well, they had three residents, two in one district and one in another, who were, honestly, they were kind of shill residents, but they were still residents. So what happened was, with the developer district, they went to court, and the court appointed interim directors who happened to be the same resident directors on the other two boards. And then those directors, resident directors, appointed the replacements until the next election.
Yeah, and I had another district, Clearwater Metropolitan District, which was a water district. It was one of these postage stamp kind of districts that there were no developers in them. And the developers screwed up. In order to save some money on taxes, on property taxes, they transferred all of their property to the other affiliated metropolitan district that was the taxing district. Well, what we did is we at that point there were no qualified electors, so we went to the Douglas County. There's a provision that if you go to the appropriate county, I think that was Elbert County. We went to the Elbert County Board of County Commissioners and requested that they appoint one of the homeowners that we entered into our own contracts to purchase property, and they actually paid property taxes on it for the purpose of qualifying them. And the county commissioners, they posted notice like required that we're going to do this, and then they appointed them at the next meeting.
And keep in mind, knocking on the doors, it's just like any other canvassing or political activity, but it gives you an opportunity to educate the community on the evils of Metro District in your community, and generate support for other things that need to be done. Roughly on every door I knocked, first half the people didn't answer the door because they weren't there, what have you. And then half of the people who did answer the door didn't have a clue, even after all of the publicity and all of the hoo-ha in the neighborhood. They didn't have a clue as to what was going on. And so it was helpful to have, I had 3 documents with me. I had a copy of the notice of cancellation of elections for the most recent election, which was 6 months before the recall. I was able to explain to them, for the last 11 years, the developer's been canceling your election. And it was during those knock on doors that residents said to me, well, they told us we couldn't. They told us we couldn't serve on the board until it was built out. Time and time again, I heard that. The other document I had was a copy of the bond issue, just to say, have you ever seen this? Have you ever seen this number? Have you ever seen that they took away your right to vote? So it helped educate, and they, got more involved and asked more questions, and were more informed about the district. So it's a great opportunity to pollinate information about the abuses and make them more informed voters. Other questions? And obviously,
we have a
Sorry.
designated person that's going to take lead on these forms. I got on a little bit late, so I'm not sure if we talked about that already.
I'm sorry, Nick, what was the question again? I missed that.
I didn't. I got on a little bit late. I didn't know if we had somebody designated to take the lead on filling out the recall petition.
yeah, that's really up to you all how you want to organize that. You know, you've got what, four or five people on the phone. You know, I'd encourage you all to get together and organize your steering committee for it and start the process. And keep in mind, Brian and I are available to, you know, help shepherd you folks up on this, answer questions, and you know, kind of help you through it as you get going.
Okay.
Yeah, basically, Nick, at the very earliest, you need to appoint a committee, which can be one or more people. And that committee basically presents the petition to the court, and then they're listed as I indicated on that. And we just looked at it. The petition, it actually has the committee members' names and addresses on there.
And Nick, we recorded this, so we can send you a recording to fill in what you weren't available for.
Okay. And then I have a question, a little bit off topic, but with the cab, is that an appointed thing and not an elected position?
Yeah, that's each of the constituent districts appoints people. So in your case, your district, Aurora Highlands 1 would appoint someone to the cab.
Okay. The reason I ask is I just went back through the minutes of the cab meetings. Well, I went to that special meeting they just had last week, and I noticed at the beginning of the meeting, Matt Hopper said that Kathleen Sheldon and Deanna Hopper were both excused from the meeting. So I just went back and looked at the minutes in the last 1, 2, 3, 4, 5, 6, 7, 8, 9 meetings. Michael Sheldon's wife has not been to a single meeting.
Oh,
She hasn't
Yeah,
been to a single meeting, and Deanna Hopper's only been to 3 in the last however many I just said.
Yeah.
So as fuel for the fire, as far as like, hey, this is a bogus board to begin with. You know, she doesn't have to attend board meetings, but you know, she can be excused. I don't buy that.
Yeah, that violates the statute. That's the kind of thing that I would bring to the court's attention.
Okay.
So, Brian, this is Gary. Since Nick brings that up, and you said earlier that if you miss 3 meetings, you're automatically off the board. What does automatically entail?
Well,
Sounds like this is. Go ahead.
yeah, it basically says that if you miss 3 meetings and you're not, I have to look at the exact wording, but basically if you're not excused, but excused needs to be for a good reason. It can't just be excused because your husband's on the board and always excuses you, you know, that kind of a thing.
Right.
The statute doesn't really say exactly how that works, but I think if necessary, I think you go to the court, or alternatively, but before you do that, I think you need to go to the you have to have a board member or maybe a citizen protest at the meeting and say, this person has missed 3 meetings now, or 9 meetings in a row, has never attended a meeting. This person either needs to resign, or we need to go to court and get this person kicked off. But it would be the appropriate court where the district is organized that would determine that.
And so presumably there's some records of all that activity that are required to be maintained. What are the steps to actually acquire that?
It would be the minutes.
It's online. I have it. Sorry to interrupt you, Brian. It's posted in the meeting minutes on the CAB website, and it says who was in attendance, who was excused. So obviously, if you weren't excused or in attendance, you weren't excused and not there.
And Nick, just so you know, Gary's in another district. He's not in your district.
Oh, got it. Okay, I'm sorry. So it's on.
Hey, Nick, sorry. I don't want to confuse anything. This is your guys' meeting. I appreciate being a strap hanger here.
Yeah.
What's a cab?
Don't worry about it. Don't want to know.
They have a structure that is gaining in popularity among developers. It's called an authority. An authority under Colorado law is an intergovernmental agency that so you have representatives from different governments that get together to form their own special authority, and that authority is a separate entity. In the case of the Aurora Highlands, they have what's called the Community Authority Board, or CAB, which is an authority under Title 29, an intergovernmental authority, and it has 12 board members, 7 of which are appointed by a 1-acre parcel of developer land that no one will ever own. It will never be developed. It's just basically raw land the developers have. So developers get to appoint 7 people of the 12 board members. The Aurora Highlands District 1, which is the only district right now that has residents in it, gets 1 board member. Aurora Highlands 2, which is a future district that hasn't started yet, another homeowner district, gets 1. Aurora Highlands 3, another future one, gets 1. And the 2 commercial districts, Artec 1 and 2, each get 1. So the developers will always have 7 of the 12 votes, even though they pay no taxes, or essentially no taxes, even though they have no development, and that authority board is set up so that it controls the issuance of the debt, it controls the taxation, it controls the spending of the money, it controls everything. It
sounds worse than a metro district.
Well, what it's doing is replacing the governing authority of a district with this omnibus board, and they get to appoint more developer voters on that board than you would have if you had a resident controlled district. So it's a way to create in perpetuity developer control of the financing decisions of the district. They simply essentially replace the governing board of the district with this superficial board, and it's an outrageous maneuver using the CAB statute. We tried to get some relief in our proposals with the legislature, but they didn't do anything with that.
This is nothing short of medieval feudalism.
Yeah, no question. And it goes back to those agreements. I mean, what Nick and his group will likely consider at some point, once they get control of their board, is addressing those agreements that create the CAB, because what created the CAB was an agreement by Nick's board, which of course is all developer, agreeing to send all their money to the CAB, and agreeing that the CAB can issue the debt, and agreeing to the CAB setting the taxes. And once Nick and others get control of their board, they can reevaluate those agreements and consider terminating those agreements with the CAB, which potentially can free them from that tentacle. But anyway, that's down the road. It's got to get your boards first.
So along those lines, when we were talking about recalling board members, for those board members who are good candidates for recall, right? Developer seats, that we want to recall them for sure. But in the instance when they're not a resident of your district, which would probably be the predominant reason they wouldn't be qualified, because they're probably Colorado voters unless they're in the military. Most developers aren't in that kind of situation, I suspect, or they're registered somewhere else for whatever reason. I don't want to call it a shortcut, but it's certainly complementary to, in parallel, disqualify them. I don't know if that applies to cabs necessarily, but is a petition required to challenge an unqualified board member, or is, if that process is too off topic, I'd love to get an idea of what those steps are, so that down here we can consider doing both of those in parallel.
Yeah, I think the answer is you don't need a petition like a recall petition, but you do need to file a motion with the court. I think you need to file a motion with the court to disqualify this person because they are not eligible electors. But you got to get your ducks in row first. That's why you've got to do the research. You got to ask your attorney, what qualifies them. Can you provide some proof of that they're qualified? And try to do it internally first, especially at meetings. Make them prove that they're qualified. And if they can't prove they're qualified, then at that point, I think you go to the court.
Okay, thanks. I mean, it sounds like technically it sounds extraordinarily more simple process-wise than going through a recall. However, I think I would concur completely that a recall effort should be an absolute part of the effort here, because there's all kinds of things that could go wrong. And yeah.
The point is, all they have to do to qualify is they have to provide proof that they have a contract to purchase property, present that to you, and show that either they paid taxes or they somehow or another paid the developer the money to pay taxes or something like that. Now maybe they can't prove that, but maybe they can, and so that's why you want to make sure that it's done right.
So, well, go ahead, Margie.
Several years ago, I challenged some of the board members on our Metro district before the homeowners really took over. And I was given some information from the designated election official, and it all came to me redacted. So I really couldn't see anything. And I think they said it was because it contained personal information. So there was basically nothing on there to even look at.
Chris, to answer your question, CAB members can't be recalled because they're appointed from the district governing boards. You can recall the member of the district board who has been appointed to sit on the CAB, but you can't recall the CAB. You have to do it through the district boards.
Let me suggest something though. I think there's an easy way to get out of that CAB nonsense, and that is to basically raise at a board meeting the fact that this is an unfair agreement with a fiduciary. Under Colorado law, unfair transactions or agreements with the fiduciary, which means in this case a board member or their affiliates, can be voided by the district. And so I think you should void the CAB agreement, for example. Wow. I think that would be one thing to do. And at that point in time, you're out of it. You're out of the pledge agreement. You don't have to pledge your property taxes. The developer, I think, is on the hook, and they're going to fight it in court. You're going to have to hire an attorney and fight it, but you're talking hundreds of millions of dollars here that you could save. They're on the hook for this if it turns out that the CAB agreement is an unfair transaction with the fiduciary, which I think it is. We did the same thing with a small district in Elbert County, North Pines Metropolitan District, back in 2009. And it went to a jury trial. And the jury found that these agreements with the developer were unfair agreements, voided them all, and awarded the district, it was a small district, but still about a $500,000 judgment against the developer. And we're still, we kicked him in the town, he's on the lam. We every once in a while garnish a bank account of his or something like that. But the bottom line is we got them all canceled.
Wow.
Yeah.
That assumes you have a board, you have control of your board, right? Because the CAB exists outside of your board.
Yeah, once you get control of your board, you can invalidate the agreement that created the CAB. So once you get in control of district, like for example, Aurora Highlands, when you get in control of Aurora Highlands 1, you can invalidate that agreement. Similarly, if you're in a master slave situation, which I think you are down there in El Paso County, if you're in a master slave situation, you might be able to invalidate the master district.
Yeah, Gary, you'll have the same opportunity with respect to those agreements that you have with the master district. And just a footnote, in terms of the fees to pay the attorney, once you're on the board, you now have a budget and you you have a legal budget and you can potentially use that on this effort.
Wow. So one backtrack question. If a board member, if you're challenging a board member who is apparently unqualified, if that board member or members become qualified, since you just raised the flag, I would presume that that's irrelevant. The fact is they've been serving on the board for X number of years unqualified. Unless they can prove it, they should be tossed immediately by whatever judge, right?
Well, the other thing is they can't, if they're not qualified at the present time and there are already residents in the district, they cannot now qualify through a contract to purchase property, because that would be a violation of what's called of the statute 321808, which says that, you know, once there are people in the district willing and able to serve on the board, you can't qualify additional electors through that shenanigans anymore.
Yeah, that exception that allows the developer employees to sit on the board only applies if nobody else wanted to run, which is why the residents in our community were told time and time again, you can't run.
Yeah.
So consequently, they could say and file, and their attorneys would say and file, nobody wanted to run. So it's insidious, but that's the game they play.
All right, thanks. I'll pull that thread a little more at another time, because I think I need to dig into a few more details that are pertinent for us.
Yeah.
Thanks.
Yeah, I just dug really quick to finish up that note. I went through every one of the minutes. Michael Sheldon's wife attended 1 out of 30 meetings they've held.
Wow.
She's been excused or unexcused every other one of them. And Deanna Hopper has been to 12 out of 30. The rest she was either not at or excused.
Here, let me give you the language, Nick, of the statute. It says, a director's office shall be deemed to be vacant upon the occurrence of any one of the following events prior to the expiration of the term of office. And that's where it lists, for example, the person who is no longer duly qualified, you know, that sort of thing. It also says here, paragraph G, if the person who was duly elected or appointed fails to attend 3 consecutive regular meetings of the board without the board having entered upon its minutes an approval for an additional absence or absences, except that such additional absence or absences shall be excused for temporary mental or physical disability or illness. My thinking is, if they just said the person's excused, that's not good enough. They actually would have to say either this person is excused because of physical or mental disability or illness, or they have to say we're allowing this person 1 additional absence. And I don't think they have technically recorded that properly on the minutes.
No. So we may not be able to do a recall of the cab, you know, but at least that might help us invalidate the agreement between our Metro District and the cab, saying not only is the cab, to John's point, you know, kind of a bogus, you know, situation anyway, because it's all controlled by the developer, but it doesn't do us any good because the board members there don't even take it seriously. They're all just puppets for the developer, as seen by the lack of attendance and the lack of following of the rules of the cab anyway. We don't want anything to do with that, so we want to sever our agreement with them.
Hey, Nick,
Yeah.
those 2 names you just mentioned, those people are different than the 2 carryovers from 2020, correct?
They've been board members the whole time. And again, you have to look at the board of the cab board, not the Metro District board. But yeah, I mean, the board has not changed except for in the very first meeting minutes, there was a resignation of someone, a name I didn't recognize. Other than that, it's been the exact same board the entire time for the cab.
Okay, so I'm sorry, this is why it gets confusing having a cab, right? So I'm mixing up 2 boards. There's the one that you're about to be a member of,
Right.
the District 1 board, and then there's the cab board. You attended the cab board, and that's the one where you're saying that 2 members have not attended, have only
Correct.
attended so many meetings. So we
Correct.
can submit something to the courts about those two people while we simultaneously do this recall for the two members of the Metro District 1.
Yeah, I don't know if we have any authority to try to do a recall of the cab board.
No,
No,
No.
yeah, we
no,
don't.
I
It's
didn't
because
think
they're
so, but-
appointed.
Yes, okay, so, but we could, like I said, use that as one of our reasonings for why we want to sever our relationship with the cab. Because, I mean, not only, everybody knows the cab is a bogus thing anyway, but like I was saying, we could, suggest that it's so bogus that two of their board members haven't attended the majority. One's been to 1 out of 30, one's been to 12 out of 30. So they're not taking it seriously. We don't want to be a part of this, or whatever it might be. I don't know how we word it, obviously much better than that, but I think that gives us a little bit of fodder, to use.
I thought Brian said though that for the not qualified absences, that wasn't a recall, that it was just something you submitted to the courts that said they're not following those rules. Can we not still do that for the CAB members?
See, I think, I'm not sure you really have jurisdiction over the CAB. I think instead, you have jurisdiction over the Aurora Highlands District 1 people. And then I think once you get on Aurora Highlands District 1 and control that, at that point, maybe even before you have control, you raise the question as to whether the CAB agreement is an unfair transaction with fiduciary and needs to be voided. And you could even argue that the people with conflicts of interest, which are the developer people, should not be allowed to vote on it.
Yeah, and they have a contract, don't they? And they have fiduciary duties to fulfill under this contract. Now, the cab is not fulfilling their terms of the contract. So you can sever the contract with the cab. I mean, they're not even showing up.
Correct, yes, agreed, yeah, and that's why I'm saying, in an attempt to sever the contract, since they voted it in, we could say, not only did they not have our interest in mind, but they still don't because they're not attending their own meetings. Again, not going to be a huge point, just a point
Yeah.
on our side to bring up in that situation. Agreed.
So I guess two related questions then. If we sever the agreement with the CAB, it's just severing TAH Metro 1 from the CAB. It's not like dissolving the CAB or doing anything to the CAB itself.
Correct.
Okay.
Correct.
The second question then is, if we do this and we separate or void whatever the agreements between TAH Metro 1, does every other TAH Metro district after us, when people start moving in, would they have to follow the exact same process to separate those agreements? Oh,
Yes.
that's gonna be fun.
Yeah.
Okay.
I tell you though, there would be such repercussions from that because
Yeah.
all of a sudden now you're not liable for all this hundreds of millions of dollars of debt. There would be such repercussions that it would be just.
Right, so Brian, just to make sure I'm understanding, the cab technically is issuing the bond, so the cab owns the debt, not the individual metro districts?
I mean, maybe I'm wrong, but that's my understanding. My understanding is the
Okay.
city issued the debt and they entered into what's called a revenue pledge agreement with TAH1. And it basically says TAH1 is going to just fork over all of its property taxes to pay the debt that the cab has. Well, I think, I mean, maybe I'm missing something here. Maybe your attorneys can explain differently, but I think a strong argument can be made that if CAB has the debt and not your district, that if you sever the agreement with the cab, you sever the revenue pledge agreement, you're done. You don't have to pay that debt.
That would be great.
Yeah, I think that's right. It's not automatic. You're going to have to get control of the board and as a board vote to terminate that relationship. But yeah, as Brian says, that's going to cause huge tsunami. And what you're going to find is they're going to come to you and they're going to try to negotiate some kind of alternative arrangement. And then that's where you're in the driver's seat, which is where you should be.
Right.
And again, you'll have your own attorney. You won't be working through their attorney. You'll have your own attorney and can negotiate whatever's in the best interest of the residents.
Right. So one more question on the once we get Metro District control of the District 1, we can then appoint who we want to the cab,
Sure.
and they can't block that.
No.
But it's
Okay.
still only one vote.
Right.
But
Yeah,
that's
if you're-
okay. But at least here's the difference though. When I've been to these meetings, Matt Hopper says, are there any public comments? And I stand up and I say, I don't like this. I don't like that. We don't like this. We don't like that. And Matt says, are there any other comments? Okay, moving on. He doesn't have to answer any questions. He doesn't have to address anything. He can just move on. But if, let's say we nominate me and I get on the cab board and I'm sitting there and they say, is there any other businesses or anything going on? I can say, yeah, Michael, how come your wife never comes to these meetings? What's her excuse? They have to answer my question. They can't just move on. So that'll be the difference, I think, is that if we sit on the board, then we have a voice, as opposed to Matt just saying, oh my God, another lousy resident comment. I'm going to listen to it and then I'm going to skip it and I'm going to go to the next thing.
So once we take control of TAH1, do we just get to say, hey, the person that was previously appointed, we just don't want them anymore, and here's our new person? Like, what's that process for, like, say, putting you on the CAB, Nick, for TH1?
They were,
I would defer to John or Brian.
at the meeting just.
I think you'd have to look at there's probably, it's probably spelled out in the documents.
But what I see in the board of directors, Matt Hopper is officially the Aerotropolis. Carla is AACMD. Michael Sheldon is the representative currently for the Aurora Highlands districts 1 through 3. Cynthia is AACMD, and then there's 2 assistant secretaries, Matt and Michael's wives. So Michael Sheldon is officially the Aurora Highlands Metro District 1 rep. We would have to probably say, we no longer want him to represent us on the CAB. We'll take that spot.
So Nick, my understanding of how it would work is that once you get control, you would be, the members would have the majority on the board, and then you would basically start exposing these disqualifications of these appointments. And if you can't get those people to step down, which I have a feeling they would, because like Brian was saying, once you have this windfall happen, they're gonna catch wind of it and they're gonna do some things and negotiate with you. But once that happens, that's when you would go to the court and say, hey, we have proof that this is an should not be appointed cab member, and we need them to be removed. And you'll have conversations, because once appointed, right, there's got to be a disqualification before they can be removed. So once you get that disqualification, then you would be in the seat of appointing a new member. But you couldn't just basically say, we don't want them anymore and we're going to appoint somebody else. You have to disqualify that appointment.
So even if Michael's the representative for the Aurora Highlands District 1, he stays as that unless we can get him or somebody else disqualified.
No, I don't think so. I don't think so.
You don't think so?
I think Aurora Highlands 1 can appoint someone different at any time.
What about the
Yeah, the
appointment
majority.
that already existed? How do you disqualify that appointment?
You say you're done.
We're going to appoint someone else. It's just,
Okay.
it's just like.
More reason to get
Aurora
control
appoints
of the
people in
metro
different committees. They
district.
do it all the time.
One
I
step.
think-
You don't have to have cause to get rid of them. They serve at will.
Okay, that was my misunderstanding, because from what I remember, they were saying that once appointed, the board has to then declare that they can either disqualify them to appoint somebody else, which if only one person, if Nick's the only one, he doesn't have a majority to appoint somebody else.
Well, the Aurora Highlands Board.
Right,
Someone.
Mhm.
right, okay.
Yeah, let's be clear. I mean, Nick's board for Aurora Highlands District 1 has to be all resident or majority resident
Control,
That's
right,
the first step, yes.
before they can do anything.
right.
Yep. Okay.
Or Nick could make the argument that the other people in their conflict of interest should not vote. He should be the only one to vote. He and the other doctor, what's the other doctor?
Westmoreland.
Yeah, Dr. Westmoreland. He and Dr. Westmoreland should be the only people allowed to vote.
Okay, I sit corrected. I will have not that much information on this newly cab thing, but that's how it used to work for the appointments that we went through, that they just refused to have somebody else be appointed once somebody else was appointed.
But if those were the only 2 people voting, then they wouldn't have a quorum. I'm worried about their procedural behaviors. If they're not having people show up for meetings and stuff, if you don't have at least a quorum, you cannot make decisions at meetings. So I'm wondering about the procedural steps. You can challenge that. And also somebody's wife on the board with them, board members aren't supposed to meet outside the board, not more than two. And so I'm wondering about procedural lapses.
That's a really good point. That's Colorado Opens Record Act requirements, isn't it? For, sorry, open meeting act, something like that.
Open meetings law, yeah.
Yeah, so that's a very good point. If they're married, then how are you can't guarantee that you're not, meeting outside.
Well, two can. They couldn't get together for dinner and discuss policy, maybe two couples, but two is okay. It's just not three.
Yeah, it's not.
Yeah, I think you have a ton, and I don't want to call it the wrong word, but I think you have a ton of ammunition here. Once you get control, you're going to be able to expose and move forward at your will. You just have to get the right pieces in place.
Yeah. One step at
Can
a
I
time.
lob? I'm sorry. Go ahead, Chris.
I said one step at a time.
Yeah.
I want to lob an interesting question, not necessarily a hand grenade by any stretch, but what is the threshold or evidentiary basis in which a breach of fiduciary duty becomes civilly or criminally relevant?
Ah,
Oh.
I'm bearing the teeth here.
that's a good one.
I mean, I don't know anything about criminal law. I don't think criminal law, so I wouldn't address that. But with regard to breach of fiduciary duty, I think that if it's acting against the interests of the residents, and it's for their own benefit, their own personal benefit, pecuniary benefit, or the benefit of other insiders such as their employers, and it's material. Material typically means it's more than just a nominal amount.
Like commingling of funds.
Well, I think that, and you look at the article, I'm sorry to interrupt you. You look at the article in the Gazette, and the claim that Matt Hopper makes $50,000 and his wife make $50,000 a month paid to be on the cab by the developer. Does that mean if I get on the cab, do I get a paid position? Is that what that is? Probably not, right? So they're literally being paid to vote in the developer's best interest. If we could get proof of that, in my mind, that's criminal.
Yeah.
We actually.
Well, what this?
Go ahead.
Go ahead.
No, that's right. Go ahead.
I was going to say what this raises, and the reason I bring this up is in consulting with one of our attorney residents here. Not that attorneys always do this, but it's like, hey, until you make this personally painful, these guys that are on these boards that don't have any reason or business being there, they'll drop like flies and say, oh, crap, I'm going to get a lawsuit. I'm out of here.
Yeah.
But that's not trivial to have a venue to pursue a lawsuit. That's why I'm just curious, hey, if I want to know what to be on the alert for, because when you find a nugget like that, that's a completely different venue than all this procedural stuff that we're basically playing with.
Yeah, we approached the Attorney General, and I don't know where those conversations are. They may have fizzled out a little bit with other things, but that was definitely something that we brought up as well. We should probably re-examine and reinvigorate that conversation again, because there is potential for criminal liability. He was saying if he looked into it, he wasn't for sure saying there was, but he said we should look into this. There's some, I think it was, what was it not, can't remember exactly what he said. Yeah, there was a term that he used that it wasn't something that he was going to let go. So if we can keep those conversations going, I think that we'd be in a good place there too.
Well, just again, we're kind of beating a dead horse on it, but connect the dots, get control of the board. Once you get control of your board, get your own attorney, stop relying on the district's attorney, and then you'll have legal counsel to work through all these issues with and do something. But you got to get control of your board and then get your own attorney and management company that'll be loyal to you.
And some of you may be thinking, gosh, this is hard. Yeah, they make it that way. And just know that if you focus on, like John's saying, the one thing, take it one step at a time. Take one step and the next step will open up. And, John and Brian it's awesome that they'll be there. And I'll be there here too, right? If you guys need circulators, I'm in Castle Pines. So I would easily, you tell me the date you need me, I'll come down and meet with you guys too. I don't have as much understanding as Brian and John do, but I learned a lot from John, and I was a part of the recall twice. And I know basically the things to look for and make sure that you're counting all that stuff. And I'll go talk to people too. I have no problem with that.
Well, and all these, the Aurora Highlands folks, you guys are such pioneers. And I can't tell you how delighted I would be if those authority boards could be gotten rid of, because Aurora City Council people were so smug when they put those together. And I would just love to see them be dismantled. So thank you all for everything you're doing.
I agree, Margie. Just for some history, do you know the Gaylord Hotel out there? They got a real cushy deal with the city, where the city is basically giving the developer, they put in a free fire station there. They gave the developer, I think it was either 20 or 30 years of free tax money, tax increment financing to put in everything there, put in the roads and everything like that. They don't pay sales tax for years and years and years and years into the future. But before they did that, there was a legal challenge where they had this arrangement set up where the companies that were going to be in the tenants, like the businesses and all that, the restaurants and all that, and all these other people in the area were going to be paying Metro District taxes to this. And they challenged, I guess it was some kind of a sales tax that was going to be imposed in court. And the judge, it was these people against the city of Aurora. And the judge ruled against the city of Aurora, saying that this whole system, this whole scheme they set up with the Gaylord was illegal. And there was a great quote basically says that in this case, they're claiming that the people that voted in the election, which were basically just one person got to vote in the election, which was the person that set up the district. The person that got to vote in the district was the taxpayer, but they said it's more like the sheriff of Nottingham voting to impose taxes, because this was just a tax collector. This was not the person that was actually paying the taxes. And so they struck that down. They later reorganized and did it a different way, and they got it put in. But Aurora, they pushed the envelope on a lot of shady stuff, and they need to be slapped down.
We'll start slapping.
Let's do it.
Well, there's
In that cab, they signed both sides of the agreement. I bet they signed as the
That's common.
district and as a cab. And I think you can invalidate that when you get to court.
Oh, yeah.
Yeah.
Especially the part that says that the 7 votes for the developers is a fair allocation of votes. No court in the world would say that's a fair allocation of votes.
Yeah.
For the Ward 2 folks, and that includes you folks in Aurora Highlands, our Ward 2 council member, Steve Sundberg, is going to have a town hall on May 19th, and it's going to be a panel of Metro districts. And Brian and Lonnie Glessner are going to be panelists on behalf of the homeowners, and then 2 people, one from that educational committee that sends all that propaganda out, and somebody from Painted Prairie are going to be representing the other side. But it will be open to people to ask questions. So I would encourage any of you to come down and sort of share your stories and ask why the city's allowing this kind of stuff.
Yep.
If I may suggest, and John, you and I had talked about this briefly, and some of this conversation certainly lends itself to this concept, but much of this is procedural. Big deal is the procedure is the same statewide. So, the variables in these equations are the individuals, for the most part, the debt and bond amounts, right? Those are just variables in an equation. But a standard form equation that provides, hey, here's the specific pieces of material you need to move yourself along this process. If we collaborate and share this amongst ourselves, it produces almost like a checklist basis for, hey, here's your Metro District. Fill in your numbers, see how it looks. Maybe you've got an angel of a developer taking care of you. Maybe you don't. but fill in the details, and you can kind of not have to reinvent the wheel, so to speak.
Yeah,
That will be a great benefit from this.
that's a good point. I mean, there are some rules of thumb, like for example, what I call the debt to assessed value ratio. Districts should have, and I know John disagrees with my numbers a little bit, but I think certainly no more than a 50%. If you take the total debt of the district and divide it by the total assessed value, it shouldn't be more than 50%. Those kinds of rules of thumb are real important. Similarly, there's provisions like the maturity of the debt. You really shouldn't have debt going on more than about 30 years. Of course, the mill levy, I don't think mill levies over 50 mills make any sense.
Yeah, Gary, you're absolutely right. There's an equation that can be made here that you just hand off once you show the proof. And we've actually had somebody in our group that had this work, and there's many others. And if you get that equation working, we will start to erode this abuse in this state.
Yes, you will.
Presumably, some of our legislators live in metro districts and might actually be interested more so. I don't know.
Yeah, you would think so. But the developers aren't stupid, and they take good care of those legislators one way or.
Yeah. The hard part is that they've got them under the guise that it's affordable housing, and we've got all these people coming here, and so we've got to change that misconception, because we know it's not affordable. It takes 2 years before you can't afford your $400,000 home because you've got $5,000 worth of taxes you got to pay each year.
I have an outstanding question still. Getting back to when you go around to collect the signatures. So, using the Aurora Highlands, there's homes that are not constantly, but there's homes that are going to be closing, continually people closing. So when you say for us, it's going to be 40%, because I just did a rough addition, using satellite imagery, and we probably have about 80 homes, not voters, but homes. So if you kind of extrapolate and say, I don't know, about 150 or 130 or, somewhere in there, right? Ballpark it. It's going to be the 40%, because we don't have 300, right? But if we go around, and we're going to need to knock on every single door to try and get as many as we possibly can, if we're doing the math, I'm worried about the timeline. If we need to go and collect signatures as fast as we can with the residents that are in the homes that day or that week, but then when we submit for review, if people are still closing on homes and the number of residents adjusts, does that work against us somehow, or does the timeline work against us somehow?
Well, just make sure you have a little bit of a buffer room, and make sure that you do it as quickly as possible, so that the designated election official, she or he would have a very short period of time to verify that. So, I think if you, let's say, for example, if you think there's 150, and as I said, you can get that number from the county clerk and recorder of Adams County, I believe. Get those numbers as to how many there would be. Estimate maybe 4 or 5 more for homes that might close. Estimate maybe another 10% just for signatures that are going to be invalidated, or 20%, and get it to the DEO right away.
Yeah, and keep in mind, the clock's ticking from the minute that the DEO certifies that your petition is, in the format that it needs to be, and the commas in the right place. You have, I think it's 60 days from that point to collect the signatures. It turns into a pumpkin after 60 days. So you have to turn in your signatures within 60 days. And then the DEO has, I think it's 5 business days to determine whether or not those signatures are sufficient. So there's some built-in timelines, but yeah, to Brian's point, you just gotta get that many more than you need as a buffer. I forget, JD, how many we needed, but we had a buffer of about 200, maybe 150.
Yeah, but to her point, we already had a mostly built out community. So I think there's a valid point there in terms of the concern of it not being built out.
Yeah,
Pulte across the street, right? I mean, it's not even just Richmond now. Pulte's probably going to be closing here soon, so we got to keep our eye on those homes, because they're going to be part of. Well, they may. I don't know. I don't even know if they're going to be part of TH1. They might be part of 2. I really don't know, but we'll have to figure that out, obviously, right? And I guess before we actually hit the streets, we need to pull the most current roster of voters so that we know,
Yeah.
do the math, and we know exactly how many we need to try and get. But then but then as soon as we submit, right, it's not like we submit and the DEO can wait until that 60-day, right? As soon as we submit, they have a week. So there isn't like this buffer of, well, so many more residents just close on houses in the meantime. Okay.
Right. And, you know, if somebody moves in, maybe they don't register to vote for, you know, a couple months or just before the next election. So even though they move in, they may not have registered to vote. So you gotta kind of nail that down. But yeah, and they're going to play games with you. I mean, we submitted our materials and we got them back because they all resigned. So I picked up all the boxes of the stuff we submitted, and they made notes on each and every petition. They counted them 3 times. And the first time they came up with a number, the second time they came up with another number, which was lower. Third time they came up with a third number, which was even lower. So they went through it and disqualified every single one they could possibly disqualify. And we still had, I don't know, 60, 80 more than we needed. So just get your buffer. They're going to play games, but they have to, you know, they're going to have to justify the disqualification. So if you have enough, you'll be fine.
I think
Sounds
the
like
key
America
for you
overcome.
guys doing the recall is really about, you know, celebrating the exposure, celebrating the education of what you know. Get out, hold events. I mean, I can speak for myself, although Brian and John have much more articulate ways of speaking to this than I do. Get on a Zoom, get email addresses. We can send out invites to email addresses when you start your recall, so that if people are kind of like, I don't even know what this thing is, we can help educate them in terms of, you know, letting them know what's going on. That's what worked for us in our community. Word of mouth, talking, just getting everybody, you know, understanding what's going on, and they'll get it.
We love doing town halls. So if you get a group of people together to talk about this, we're happy to come and do a dog and pony show on the horrors of Metro District abuses specific to your community, using your documents to tell the story.
I was just going to ask that, John, if, you know, what's the success or engagement rate that you've seen? Because as we know, most people have never heard of a Metro District. It's amazing when I meet somebody that knows what it is, because I had heard of it either. But how useful are tools like that? Because our newly elected, unofficially elected directors, we got a 2 to 3 to 1 margin win over our developers, just based on our email campaign to reach as many people as we could with the information that you helped us compile and several of us worked on. It's another matter, though, to get people to, hey, we're all going to meet at this restaurant or something, and go out of their way.
Of the people that I talked to, 5% didn't sign the petition.
Well,
Through
if you-
door-to-door engagement, right?
Just show them the tax bill and the amount of taxes, show them the amount of debt. That'll make a difference.
And
Yeah.
if you have a meeting, have food. People come for food.
Well, yeah, I was going to suggest if you've got a clubhouse, and that presumably the homeowners can use or rent, you could just do a potluck.
Yeah.
Well, interestingly, I talked about this with one of our new board members, presumptive board members, about, hey, the developer actually has their headquarters here in our neighborhood. Like, why don't we invite the developer? Say, hey, let's meet all your board members. Come on out, and invite the community to come out and ask questions. That way, we can ask pointed questions or very specific questions, and I don't know, but that would be an interesting venue to host in. No kidding, right?
Yeah, you'd probably have a lot of excused absences.
And again, just to beat a dead horse, there's really no replacement for door-to-door conversations about this. That's really the only way you're going to get people educated.
Yeah, I hear you. Thanks.
It's hard. It takes time, but that's.
It's actually a good way to meet your neighbors. Sorry to interrupt you, John. It's a great way to meet your community. I mean, that's what we did. I met so many great people in Solterra just by knocking on the doors. And again, you have to get past that trust factor, right? Which is, some people are always gonna be like, you're soliciting me. What are you doing? Keep doing it. Just get out and talk to them, be vocal more than you would be. What I've noticed in new communities, people don't talk very much. And if you're out there doing that, you're going to promote conversation and education.
Right.
One of the things I was thinking about is the article, right, that the Gazette published about Aurora Highlands in December, printing it off and taking it around and giving them a copy and say, here, just read this article about our community. This is what's going on.
Yeah.
And then here's our
100%.
contact, or here's how we're connecting everybody up or whatever. But here you go. Just read this. So
Yeah. And you could, you could pull out, one or two paragraphs if, some people just won't read that much, but if you pull out a paragraph or a couple sentences, the gotchas, the grab yous, and then say, here's the rest of the article. Yeah, absolutely. Because, what's the rule? You've got like, I don't know, 10 seconds, 15 seconds. And if you can't get their attention in the first 15 seconds, then, you're gone. So
the elevator pitch.
And then hopefully they'll be hungry for more information and you can give that to them. But,
yep.
So anyway, it's there. We've been at it for almost 2 hours, guys. Happy to keep going, but
I got to drop.
more work to be done, and we just have to break it down and take it a step at a time. And the other important message is you ain't alone. Everybody here has been through it in one form or another. There's probably 1,000 others out there like you. I've been dealing with 3 or 4 other districts last couple of weeks, similar situations. So it's great that you guys I figured it out soon enough to do something to help your residents. And as I say, there's a lot of experience behind what we're doing, and we're happy to share it with you.
I would say have fun with it, because the last time I did a recall as a union steward, I had to recall my entire board, and I had fun with that. I'll still remember how great that felt when they trembled. And we got rid of them. It can be very rewarding in the end.
When I did this with John, I couldn't get past for a while. It took me probably a couple, I don't know how long, but it was at least a couple of months. I couldn't get past how much of a victim I was. It really angered me. And all I would say to you in terms of what I think Reese also said, let that drive your passion for joy, because if you do these things over a long period of time, slowly and in the way that you're doing it, it's gonna be just that much more rewarding for you. So I just sharing with you how I felt. I was pretty down when I heard about it. I was very angry. I said, they've got an unconscionable contract. How can they, I couldn't go anywhere. I was lost. And it almost made me want to do the same thing, which a lot of people do, which is move out of their community. Well, if you just keep doing that, then, you're just creating gentrification of people who can afford these high taxes. And that's really not what we want in any place. You want to be able to afford the place you live, and you want to, denote and get rid of all these abuses. So you have our email addresses. Zoom meetings are easily set up for you guys. If you get more email addresses from your community and you want to do another one of these, we can do them. You just have to let us know.
Appreciate it.
Well, I'll quickly thank everybody for allowing me to come in. I'm way down here in the Springs. Brian, John, JD for setting this up. This is really fantastic. This is actual gold. I've got a lot of notes and a lot of things to follow up on as myself, and we had one guy, Chris, from our Metro District that had joined. So we've got folks that are interested in knowing more about this, and I appreciate your support. More to follow for sure. Thank you very much.
Yes, we are watching and we are there, whatever you need.
Yep. Thanks, Brian. Thanks, Carice. Thanks, Margie. And thanks, Fair, for tuning in and helping out. And Brian, thanks for your leadership on this. Appreciate it.
Yeah, for sure. Thank you.
Take care. Good luck.
All right,
Thank
thanks,
you.
everybody.
Have
Good
a great
information.
weekend.
May I ask a question, John and Brian, before everybody else, before you leave?
Yeah, anybody that
What
doesn't have
happened
anything to
today at the
do for the
committee
rest of the night could sit in on the Senate hearing soon.
That's where I'm going to. I don't know if they'll get to it, John. I've been looking at it. It's far.
Looks
I know
empty.
Still going on?
The goofballs are still
Still
running
going
it
on?
out in the Senate.
It is
I've-
still going on. They're at HB
Fentanyl bill-
22 1399, so we still are a ways to go.
The fentanyl bill in the Senate is still going.
Oh, really? Are you
It's
guys-
going on all night.
So you guys are all testifying via Zoom?
I'm
Yeah.
not down there, that's for sure. I learned my lesson last time.
Yeah, it depends on, yeah, poor Brian, geez.
I can't imagine this is gonna get heard tonight.
I don't think it will. They're
I'm
only
waiting.
at the music therapist title protection. It's like 1399, and I think they've got, if I look at the list, they've got, oh man, it's like at least a dozen more bills to go. At least.
I'm waiting
I
for the
have to
license
ask,
plate bills.
Why do Weissman and Bassnicker want this to pass? I don't understand.
They're beat down.
Yeah, they got beat down.
Weissman, I think Weissman just wants to.
They're just beat down.
constituency-
Weissman's last comment to me was, they've just got too many guns. And I said, what? That doesn't compute. So anyway, so
Oh.
from my standpoint, whatever happens, we have to make a statement as an organization. We have to
Yeah.
establish the integrity of what we do and what we say, and then try to translate that into political action one way or the other afterwards. But if no one sits in that meeting and says what has to be said, then to hell with it. And if we're the only ones, then we have to do it. We have to make a
Well,
record. We have to make-
I'm so fed up with Jefferson County. I'm ready to leave the Democratic Party over it and just become an independent. I'm just so pissed, but,
It's an opportunity to
I-
make a statement.
yeah, I haven't, so you don't know how, I didn't hear back from Pete, so I don't know what he'll do. He knows how I feel about my metro districts. I talked to him about it last year and he didn't know anything about them. And I spoke with him.
Yeah.
So I don't know what kind of luck have you had with those other two Democrats on the committee?
Well, we know Coleman really well. I've had really good conversations with him, several years ago with Gail. Gail knows him real well.
Yeah.
Lee, we don't know the third one really well, but I think Coleman is listening. But if hold on, if Mike and Andy and Tammy aren't pushing to remove the Republican amendment, then they're probably not going to do it. So from my standpoint, I think we have to make a statement. We have to make a record so that, whenever it comes up again, somebody says, well, why didn't somebody stand up and say something? At least we can say we did, even if the legislators won't.
Well, I'm sorry I'm not there. I'm down in Arizona, but, anyway. Okay, thank you.
Yeah, that's where we are. Join the party. All right, anything else, guys? Okay, thanks again, Brian. We'll see you soon, I guess.
Thanks all. Talk
Bye,
to you soon, I
everybody.
hope.
I'll get this out to you guys as soon as the recording's done so you can look at it again.
Yeah.
Thanks, JD. Really, I've got some folks that couldn't make it and definitely want to learn from this. This is fantastic information for us newbies.
You got it.
Have a great weekend.
You too. Bye-bye.